Thank you, Venki. So, Venki had given a succinct explanation of both the 10 INSEE tests. He described about the 6 INSEE tests. The first being on well-definedness, and the 5th and the 6th, which talked about independent and non-equivalence. And we saw this test, the 5th and the 6th test, helps us to stops us from creating false semantic height. So, before moving on to the 7th test, I thought I'd give a brief background about the non-obviousness position in India. So, with regarding to the patent jurisprudence, we have this very important landmark case, the Biswanath Prasad versus Hindustan Metal Industries, wherein they held that the new product or process must involve invention over the old. So they stressed upon the fact that there must be ingenuity embodied in an invention that makes it substantially different from the prior art. And also they talked about the exercise of any inventive faculty which should be above the skill of an ordinary person. So we see that they have reiterated the fact about the creativity or inventivity which should be embodied in an invention. This judgment has been codified in the definition of inventive step under section 2JA of the Patent Act. So after having a background about this case, looking at this with the inventive concepts test, we see test number 7, which has been termed as the novelty and non-obviousness test, the nano test. So when we apply the nano test, we get the set of inventive concept which is embodied in an invention over a prior art. So applying these tests, we further quantify creativity by building the semantic height, which is based on the independent creative thoughts that go into making an invention. So thereby, building the semantic height, we are able to measure the technical advancement of an invention over the prior art. Further, this test also checks the reasons causing creativity or inventivity which is embodied in the claimed invention. Thus, we see the nano test is being able to objectively measure the non-obviousness and the creativity or inventivity which is embodied in an invention, and this is very much compatible with the Indian jurisprudence and the section 2JA of the Indian Patent Act. Moving on, we see that any inventive concept, even though it's novel and non-obviousness, there are some additional parameters which are to be satisfied so that it can be patentable subject matter. Now, with regard to the Indian position, we know that we have section 3 which given us a list of exclusions, and some of them being frivolous inventions, admixture, plants and animals, mathematical or business methods, etc. And regarding the inventive concept tests for patent eligibility, we have 3 tests. The test 8 being not only being a natural law, test 9 being idempotence, and test 10 not only an abstract idea, the NIO test. So I've just listed down these tests. I'll be explaining it in detail in a few minutes. So the test 8, so it talks about not only being a natural law. So under the inventive concepts test, so each of the inventive concept is analyzed whether it is just only a natural law. So this test 8 checks whether it is just only a natural law as in. So if you see the patent jurisprudence around the world, for example US, it is a judicially crafted exception that a natural law cannot form a patent eligible subject matter, and it has been reiterated even in the recent cases such as Myriad and Maya versus Prometheus. So in India, we have section 3C of the Indian Patent Act which specifically mentions that exclusions of patentability that simply embody a scientific principle. So test 8 bars inventive concepts that is going to contain only a natural law. Next is test number 9, which talks about idempotence. So what is idempotence? This test, it checks whether the inventive concept goes beyond the natural law or an abstract idea. So this helps to make a distinction between patent eligible inventive concepts and patent ineligible ones. This test basically checks checks about non-idempotence, whether it is a patentability logical complement to not being only an abstract idea or not being only a natural law. So therefore, it checks whether it goes beyond the inventive concept is more than it's an application of a natural law or an abstract idea. It goes beyond the natural law. So this test, in tandem with nano, determines the quality of invention. Therefore, this also quantifies the creativity which is being embodied. So it ensures that the creativity that is embodied in an invention does not fall within the exclusion of a national law. So if we go into the idempotence in the Indian patent regime, we see section 3E and section F, which bars invention that does not result in a new result or a new article or a better or cheaper article. In idempotence, we check whether the inventive concept provides an effective solution to a particular problem. So same way, here we check whether the inventive concept produces something new or not. So section 3E and F bars invention that does not produce any product or a result or a process with something new. In regarding to this, we have the recent case law, LLM Limited versus Bajaj Auto, wherein the court reiterated that when there is a mere rearrangement or arrangement or duplication of known devices which act independently of another, it is not going to create any new devices. So that time it does not become a patent eligible subject matter. So here section 3E and F we see checks idempotence, but in a different manner as well. And the last test being the NIO test, the not only abstract idea test, where I'll just have a brief background about the Indian perspective regarding abstract idea. We see that the exclusion has been mentioned under section 3K. So the IPAB in Yahoo case also held that when there is a technical advancement present, but if it's present in a business method, since business method under section 3K is considered to be an excluded subject matter, it cannot be patented even if there is a technical advancement. So a technical advancement found in a subject matter which is excluded cannot form a patent eligible subject matter. So here, this business method, this invention was held to be non-patentable. So this decision was made by the IPAB after identifying the problem to be solved. And looking into the judgment, we see the steps followed by the judgment is in congruence with the NIO test as in. So going into the 10th test under the inventive concepts test, we see NIO is not an abstract idea only, which means it tests whether the inventive concept is just only an abstract idea. So it comprises of 4 steps. First is, it verifies if the patent specification implicitly or explicitly discloses a problem set to be solved. Secondly, it verifies whether it solves the problem. Thirdly, it verifies whether same results for this invention can be achieved if we remove that particular identified inventive concept, and if on combining the other prior art, it solves the same problem. Thereby, it checks for preemptiveness. And in the 4th step, it says that if all steps 1 to 3 are executed successfully, then the described claimed invention is not only an abstract idea. So, this was an overview about all the 10 inventive concept tests, and we see that under Indian patent system, if we start analyzing the invention as elementary concept, we would get logical, intuitive, workable results which should be unanimous with the other results across the jurisdiction. And steps of disaggregation would determine subject matter eligibility with much ease and precision in addition to novelty and non-obviousness. So this would bring in more objectivity in determining the patentability of an invention, reduce a lot of subjectivities, because in the contemporary world we see inventions which are not patent eligible matters being patented, and inventions which are supposed to be patented have been rejected or invalidated of patents. So application of the INSEE test which will remove all these confusions, and this could be a panacea for all the problems as in. So it is observed that the inventive concept test is very much compatible with the Indian patent regime, and the same could be used by jurors and examiners for quick analysis, and hence more precise results could be achieved in a quicker time frame. Thank you.